Wike and his men suffer setback in court as there are moved to reassign their case files. Hello viewers and welcome to InfoGist TV. A federal high court sitting in Port Harcourt, Rivers State, has discountenanced a petition filed against the court by Martins Amehule to the Chief Judge of the High Court, seeking to stall the hearing of a case seeking to declare his seat and those of the 24 others vacant at the High Court in Port Harcourt. Both parties and others as plaintiffs in suit number FHC/PHC/269/2024 are praying the Federal High Court holding in Port Harcourt to declare the seat of Amehule and 24 others vacant for the campaign from the People's Democratic Party (PDP) to the All Progressive Congress (APC). The suit, which was instituted sometime in December, has continued with lots of legal firepowers, with the PDP and the APC seeking to be joined as parties in the suit. When the court resumed on Monday for hearing, the court was confronted with a petition signed by Martins Amehule addressed to the Chief Judge of the Federal High Court, Honorable Justice John Shoho, seeking the case to be reassigned to another court. The presiding judge, Justice Stephen Delio-Pam, who read the petition in the open court, noted that the petitioner, Amehule, was praying the CJ of the High Court to stop the hearing process and reassign same matter to another court. Pam noted that the petitioner claimed in the petition that the court has refused to allow other interested parties to the suit to join. When the petition was read, counsel for the plaintiff both party, Mr. Ruben Wanoho, told the court that the petition was aimed at arresting the ongoing case and urged the court to discountenance it. Wanoho argued that the petition that was not served on the parties was an impudence, saying, "I urge you, your lordship, to totally discountenance the petition as it is targeted to arrest the proceedings. If your lordship bows to this later, then you have allowed the litigants to determine pending applications before the court, even before they are heard. It is not part of our jurisprudence that the determination of motions for joinder will form the basis for the transfer of cases. The application is a slap to the temple of justice and all of us who are workers in that temple." Also, the National Legal Advisor of the People's Democratic Party (PDP), Adeyemi Ajibade, a senior advocate of Nigeria, had insisted that there was no intention by the court to shut out anyone from joining in the suit, adding that the petition is ill-intended. However, counsel for the first to 25th defendants in the suit, Ferdinand Obi, a senior advocate of Nigeria, denied knowledge of the petition by his client, but prayed the court to adhere to the petition and stop further proceedings if the latter was addressed to the CJ of the court. Obi said, "I know nothing about the petition, even though it was addressed and it was written by the 15th defendant. Be that as it may, my lord, if the letter is addressed to your lordship, then there may be grounds to consider the submissions. If it is not addressed to you, then you have no grounds to discountenance it. It will be wise to await the decision of the Honorable Chief Judge of the Federal High Court, of whom the letter was addressed. We do not know if the CJ will ask you to go on or to stop the hearing." In response to the judges, Pam stand that the defense has not filed counter-affidavit to the originating summons. Obi noted that he was yet to file affidavit on the suit, adding that none of the motions for joinder has been served on him. Obi also said that they haven't filed their counter affidavit to the originating summons. However, there's a reason for that, Your Lordship, because at the point of filing the counter affidavit, the application for joinder came in. In his words, I am not within time to file the counter affidavit. We are not within time to file same, my lord. However, the presiding judge, Pam, noted that in the first instance, the petitioner, Amihule, has no motion counter affidavit before him and that he is not yet known in the case. Pam in his ruling noted that the petitioner has not copied his petition on the plaintiffs, noting that the court would have no other option than to discountenance the petition and move on with hearing of motions for joinder. The judge, who discountenanced the petition on the said grounds, further adjourned till Friday, the 28th June 2024 for hearing of pending motions. We should recall that the Court of Appeal in Abuja has refused to reverse the removal of Martins, Chike, Amehule, and 26 others as members of the Rivers State House of Assembly. Now, in a ruling which was delivered visually on Friday, the Appellate Court says giving a verdict reversing the decision of the Federal High Court, which declared their seats vacant, will amount to prejudging the appeal currently before it. The three-member panel also fixed June for the hearing of the appeal by Amehule and others, which is a request to get back their seats as members of the State House of Assembly. The justices prayed all parties in the matter to maintain status quo. We should recall that and cease every form of hostilities until the matter is heard and decided. A Rivers State High Court in Port Harcourt had on Monday 10, 2024 stopped Martins Amehule from parading himself as the Speaker of the Rivers State House of Assembly. The court gave the order after considering a motion brought before it by the new Speaker of the House, Victor Jumbo, and two others, to the effect that his seat had been declared vacant. Justice Charles Wali, while ruling on the motion ex parte, also barred 24 other members of the Assembly from accessing the complex or carrying out any such legislative assignment in the name of the Rivers State House of Assembly. Dissatisfied with the verdict of the State High Court, Amehule and others has approached the Appellate Court for justice.